Hey guys, good afternoon, everybody. I'm back, and as promised, I was going to read the first part of the motion, and then later on we'll read some of the other things. But right now, let's go ahead and get on reading, and I will have an assistant afterwards to help me with the reading. But in the meantime, let's go ahead and read this. This is Derrel MCDavid requesting the legal fees and the litigation expenses, and gives a good argument. Pretty Brown Eyes, check your email. I send it to you. You want to come and help me? I just sent the email to you. Maybe we can get Miss Pretty Brown Eyes to help us out a little bit. If she's up. All right, guys, let's go ahead on and start with the reading. Hey, Ash. I promised I was going to get on here and read this stuff over to you guys. All right, here we go. Let me tell my sister to get on. Hold on a second. My fingers are feeling like tight today. I don't know why. All right, you guys ready? Shout out to Lady Coltrane for praying for me today. Shout out to Lady Coltrane. You know, you need the prayer warriors to come on in. All right. United States District Court, Northern District of Illinois, Eastern Division. United States of America versus Derrel MCDavid. Case number 19 CR 567. Honorable Harry D. Linenweber. Motion for attorney's fee and litigation expense pursuant to the HYPE Amendment 18 U.S.C. 3006A Note and the Equal Access to Justice Act 28 U.S.C. 2412. All right, let me put the link in here. All right, it says, now comes now the defendant, Derrel MCDavid, by and through his attorney, Bo B. Brentley, and move this court for the payment of attorney's fee and litigation expenses pursuant to the HYPE Amendment 18 U.S.C. 3006A. Note, the Equal Access to Justice Act 28 U.S.C. 2412. In support, he states the following. Introduction. The government has stretched this case well beyond reasonable limits while attempting to bring indictment against Mr. MCDavid, docket number 7-4. This fact was recognized by the jurors who, after sitting through weeks of irreconcilable, inconsistent testimony from admitted liars, thieves, and extortioners, performed its civic duties and acquitted Mr. McDavid of all charges. Docket number 336. Though it may be easy to succumb the sensationalized allegation, guilt by association, and the prevailing fervor of the moment, the jurors in this case did not accept easy as an answer. Instead, they did their duty and ensured that the constitutional guarantee that Mr. McDavid be presumed innocent until proven guilty, amounted to more than mere words recited during jury instruction. One might expect government agents and prosecution investigation in bringing these charges, government actors who have a duty uphold this and all other constitutional protection would too be able to say no to the easy answers and cease to bring charges against someone when the evidence about them is irreconcilable, conflict, and incoherent. In this case, those actors fail to live up to this expectation. Thankfully, Congress has not left those who prevail in defending against the unfounded allegation of crupious and overzealous prosecution without a remedy. Oh, child. In 1997, keenly aware of the harms such prosecution inflict on their defendant, Congress passed the Hype Amendment, allowing a prevailing criminal defendant to recover reasonable attorney fees and other litigation costs where the position of the government was vexatious, frivolous, and in bad faith. The case against Mr. McDavid, was just that. From the commencement of the investigation through the pendency of the trial, the prosecution of Mr. McDavid was vexatious, frivolous, and in bad taste. They say it again. The government's reliance on the testimony of witnesses who irreconcilably contradict each other on key aspect of their respective account of event, as well as contradicting themselves repeatedly in various statements under oath, illustrate what can most charitably to the government be described as calculous indifference towards the truth. Moreover, the government made no legitimate effort to correct and at times embrace clear and undefiable falsities imposed by their witnesses. Making matter even worse, the government's witness did not tell the story as sought. The government cut its own narrative. Uh-oh. Hey, Tamiria. The government cut its own narrative from whole cloth and with no factual basis. Though the jury saw through the lies and false narratives endorsed by the government, that is not the end of the story authored by Congress. The government must be held accountable for its vexatious, frivolous, and bad faith prosecution of Mr. McDavid. The Hype Amendment entitles Mr. McDavid to recover attorney's fee and litigation costs he incurred in defending his liberty against the unfounded charges. Background. On June 13, 2008, Robert Sylvester Kelly was acquitted of all charges following his trial in Cook County, Illinois. More than 10 years later, on July 10th, 2019, a grand jury returned the indictment charging Mr. McDavid with allegation of illegal conduct stemming from his representation of Mr. Kelly in the decade leading up to Mr. Kelly's 2008 acquittal. Of the 13 counts of the indictment, 4 listed Mr. McDavid as a defendant. Count 5 alleged conspiracy in violation of 18 USC 1519, destruction, alter, alter, alteration, and falsification of records in federal investigation and bankruptcy. Count 6 alleged conspiracy to receive child pornography, namely 2 alleged tape that formed the substantive charges received child pornography in count 7 and 8. Each of these charges against Mr. McDavid were factual and legal unsound. Beginning with count 5, the government argued that Mr. McDavid conspired with Kelly to violate 1519. Given that the statute has a 5-year statute of limitation, the government endeavored to torture the fact to allege that some conduct occurred after 2014, which could extend the statute of limitation and make the offense chargeable in 2019. Both the substantive allegation of the charge itself, as well as the government's attempt to bring the charges within the statute of limitation, suffered from critical factual and legal deficiencies. For instance, the government alleged that Mr. McDavid made payment to Jane and James' family to buy silence in furtherance of the conspiracy. From this, approximately 2000 and approximately 2015, Kelly and McDavid made payments to and bought gifts for minor 1 and minor 1's parents with the intent to pursue and induce minor 1 and minor 1's parents to conceal, cover up, falsify, and make false entry in any record, documents, and tangible objects about Kelly's sexual relationship with minor 1, to continue to abide by previous false statement and entries in which items, including the existence of multiple video depicting Kelly engaging in sexual contact and sexual act with minor 1. Docket 93 at 12. However, both Jane and Jane's mother, Susan, denies that any payments were made for the purpose of concealing anything, and particularly that Mr. McDavid had never suggested that either of them lie. Susan's testimony on the matter makes clear that there is no truth to the government's allegation. Question. So these are the questions from the testimony, guys. Question. So there wasn't any money that your family was getting that anybody ever told you to connect to lying, was there? Answer. No. Question. None of the money your family ever got ever suggested to you that it was connected to being silent about anything. Nobody ever suggested that, right? No. You never believed that, did you? No. In the few conversation you have had been involved with Derrel McDavid, he has always been respectful, correct? Correct. Have you never had any issue with Mr. McDavid? Have you? No. Mr. McDavid has never threatened you, has he? No. And Mr. McDavid has never suggested that you lie about anything, has he? No. 8/22/2028, transcript at 1288-89. Moreover, Jane flatly denies that her relationship with Kelly after 2008 acquittal had anything to do with any effort to conceal or cover up anything. 8/19/2022, transcript at 87374. There was no testimony at all indicated that any payment made to anyone after 2014 was all connected to buying silence. Yet, that is, the government told the jury, even though its own witnesses said there was no such purpose for these payments. With regards to counts 6 through 8, the prosecution appeared to completely abandon its responsibility to make sure that the charges it brought were factually sound. As a primary matter, the witnesses critically contradict each other on fundamental aspect of these testimony. Therefore, neither the jury nor the government could reasonably believe that all of the witnesses were simultaneously telling the truth. The following were merely a few illustrations of this failing. Chuck Freeman claims to have had conversation with Lisa Van Allen regarding the location of the tape. He claimed that Van Allen told him that the tape she stole was located somewhere in Georgia. Lisa denied having any such conversation with Freeman. Lisa Van Allen denies that the tape stole were ever sent to Georgia by anyone at any time. Lisa claims that the tape she sent to Keith Morrell contained video 2, video 3, and video 4. Morrell claims that the tape only had one scene, which appeared to be normal threesome. Hold on. Normal threesome. Hold on, let me put the link in there. I'm sorry, guys. I lost my spot. Appeared to be normal threesome with Mr. Kelly and 2 women. Lisa Van Allen claims that she watched the tape containing video 2 and video 3 and video 4 with Mr. McDavid after Morrell provided it to him. Morrell claims the tape he gave Mr. McDavid did not contain video 2 and video 3. Chuck Freeman testified that the tape Morrell possessed depicted a threesome scene on a bed. Van Allen claimed the tape she sent Morrell occurred in Kelly's log cabin room. Van Allen testified that she watched the tape with McDavid in March of 2007. After Morrell brought the tape, Morrell denies being at any meeting with McDavid in March 2007. These points are a few examples of a problem with the persuasively plagued the government's case against Mr. McDavid. The government had one story to tell the jury. They explicitly asserted that 1. Lisa Van Allen took a tape from Robert Kelly. 2. That tape contained video 2, 3, 4. Number 3. Chuck Freeman recovered that stolen tape from Georgia. And 4, a copy of this tape was provided to Derrel McDavid by Keith Morrell. That was their story based on the testimony of their witnesses. They absolutely had to know that it could not possibly be true. They knew that Chuck Freeman said the tape he recovered did not contain any threesome scenes. They knew that he said he never possessed video 4. They knew that Lisa Van Allen claimed that video 2, 3, 4 were on the one and only tape she took from Kelly. That obviously means that Chuck did not recover the video Lisa took. Furthermore, they knew that Van Allen said she gave the only videotape she took from Kelly to Morrell, and that it never went to Georgia. So they knew that Freeman could not have recovered any tape taken by Van Allen from there. Hold on, y'all. I'm bringing Miss Pretty Brown Eyes in. Okay. They also knew that Morrell said he never possessed any video containing video 2 or 3. So the video Chuck gave to the government could not have been a copy of the one that Lisa took from Kelly and gave to Morrell. That means that from the very start, the government knew that the theory that there was a tape stolen by Lisa, recovered by Chuck, and a copy of the tape given to McDavid by Morrell was false. The testimony of their own witnesses would not allow the story to be coherently told. They knew it, yet they told it anyway. They presented these irreconcilable, inconsistent, and incoherent witnesses to a jury and tried to pretend that they told a story that they simply did not and could not. The government's theory about video 2, 3, and 4 could not possibly be true based on the testimony of their principal witnesses. But they presented it to the jury anyway. They told a story that their evidence said could not possibly true. I'm sorry. They told a story that their evidence said could not possibly true. That is surely reckless indifference towards the truth. The government's witnesses against Mr. McDavid did not only contradict each other, they critically contradict their own prior statements. Lisa Van Allen's testimony in this case was particularly striking, given that its critical contradiction by her own prior statement made under oath. Particularly, Van Allen asserted in this trial that she stole a tape containing 3 scenes, 2 of which depicted just Robert, Kelly, and Jane. I have never seen a tape with just Robert and Jane. Only me, Robert and Jane. Exhibit A. This apparently was not something the government saw fit to inquire into, as it is, as it this, I'm sorry, as it this statement did not fit its theory of the case. But it remained under oath testimony, but which they were very much aware. This disregard for the truth was not merely an issue at trial, but also infected the grand jury's proceeding. After the government learned that Lisa Van Allen had not been accurate or truthful about how old she was when she met Kelly, the prosecutor deliberately misled the grand jury as to Van Allen's untruth. If you recall, her testimony was that she met him on a video shoot for the video Home Alone, which happened in Georgia, where she lived, and obviously that was in a long time ago. She had estimated it happened in 1997 or 1998. She couldn't be sure exactly when. Exhibit B at 1516, the government characterization of Lisa Van Allen's grand jury testimony is particularly striking when read alongside what she actually said at the grand jury. I met Robert Kelly in late 1997 or early 1998 in Alpharetta, Georgia, when I was 17. Robert asked me how old I was, and I told him I was 17. A month later, when I was still 17, I called Robert using the phone number that he gave me. Not only after that, Robert flew me back to Chicago at least one more time when I was still 17. Exhibit C. Though Van Allen was uncertain of the precise year, she was unequivocally certain that she was 17 years old. The government thus mischaracterized Van Allen's testimony to the grand jury in a way that it completely at odds with her statement. They led jury to believe she expressed some uncertainty as to her age. She did not. With regard to Chuck Freeman, the government had heard this witness testify in a matter completely different from his prior statement. This is not a matter of minor inconsistency. The witness told an entirely different story each time he spoke to the government. The government was reminded of its obligation to correct perjurious testimony under Nape versus Illinois. Yet it made no such attempt on its own. The government poised that it could not determine which aspect of Freeman's testimony were true or false. The government's opening statement, however, relied on completely different version of facts. That that no, I'm sorry, than that which came out during the witness testimony. For instance, the government told the jury that they would hear the following testimony from Freeman. Freeman actually met with Brown and Kelly at Kelly's home, and Brown placed a copy of video 4 into the VCR for Freeman to watch. Kelly asked Freeman where the copy of the tape was that contained video 4 because Freeman had bought them only contained video 2 and 3. 8/17/2022, transcript at 485. The government prediction of Freeman's testimony was entirely different from Freeman's actual testimony that McDavid, in fact, played the alleged tape for Freeman and that Kelly was not present in the room. Freeman's testimony is replete with such inconsistencies. The court noted them itself during the course of the trial. The government had to notice them, yet it proceeded to present his testimony anyway and argue that it was true. The government's open statement also mischaracterized the statement their witnesses had made prior to trial. For instance, the government stated that Freeman continued to investigate and learned that Keith had a tape containing video 2 and video 3 and video 4. It is unclear from where the government found support for this statement. Morrell has at all time maintained that his video contained only one scene. Freeman has maintained that any tape Morrell had was different than what he claimed it possesses. Such mischaracterization of the statement of the government's witnesses at best is reckless disregard for the truth. The continual disregard for the truth in prosecuting Mr. McDavid is not the standard that prosecutors must be held to. The United States Attorney in the representation of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. Burgess versus United States 295 USC 7888 1935. United States versus Bagley 473 US 667 665 N.6 1985. In this case, the government apparently ignored that obligation. It brought unfounded charges against Mr. McDavid based on merely its own ipsedixit, dipoxy, whatever, and no effort to determine which, if any, of the witnesses' many conflicting stories were true. They presented a theory to the jury that their witnesses' testimony proved incoherent. Legal standards. The Hyde Amendment authorized the court in a criminal case to award a reasonable attorney fee to a prevailing party other than the United States if the court finds the government's position was vexatious, frivolous, and bad faith. United States versus Sierra 482, but there's a bunch of numbers. Okay, we're going to keep going. The Hyde Amendment provides a prudent part that during fiscal year 1998 and any fiscal year thereafter, the court in any criminal case pending on or after the date of the enactment of this act, November 26, 1997, may award to a prevailing party other than the United States a reasonable attorney fee and other litigation expense where the court finds that the position of the United States was vexatious, frivolous, and in bad taste, unless the court finds that special circumstances make such an award unjust. Such award shall be granted pursuant to the procedure and limitation, but not the burden of proof, provided for an award under Section 2412 of Title 28 United States Code. Fees and other expenses awarded under this provision to a party shall be paid by the agency over which the party prevails. All right. The entitlement to the award of attorney fees and litigation expense under Hyde Amendment. A criminal defendant must show that 1. His trial has been progressed during fiscal year 1998 and subsequent year. 2. His net worth was less than $2 million. 3. He had been a prevailing party in the criminal case, even though the subject is possibly retrial upon remand. 4. That his legal representation was not the result of court appointed. And 5. His attorney fees and costs are reasonable. Okay. Then the Hyde then gives a footnote there. Position of the United States was vexatious and frivolous and in bad faith. 18 USC 30068. Note: the defendant was in the underlying criminal case bear the burden of demonstrating these requirements by the preponderance of the evidence. United States versus Terazakis. The defendant needs to establish one of these elements to be entitled to recovery under the Hype Amendment. United States versus Monsum. To satisfy this burden, a defendant needs not to show that each position of the government was vexatious or frivolous or in bad faith, even if the district court determines that part of the government's case has merit. The Mavant might still be entitled to the Hype Amendment Award if the court finds the government's position as a whole was vexatious, frivolous, and in bad faith. United States versus Heverin, whatever the name is, which the party postures in the individual matter may be more or less justified. EAJA, such like fee shifting status, favor treating in case as an inclusive whole or rather autonomized line item. Okay, we're going this part. It's boring stuff. It's just explaining that case. Okay, blah 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 blah. Okay, blah blah blah. This is boring stuff here. Hold on. Like vexatious. Okay, we don't need to read that. Blah 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 blah. Okay, here's the argument. Argument 1. McDavid is entitled to attorney fees and litigation costs under the Hype Amendment and Equal Access to Justice Act. A consideration of the government's position as a whole with respect to Mr. McDavid demonstrate that he is entitled to an award of reasonable attorney fees. The government told the jury stories that had to be false based on the collective testimony of its witnesses. The entire theory about the Van Allen tape contained in video 2, 3, 4, which they claim was sent to Georgia and recovered by Freeman, could not possibly be true. If their witnesses were all taken to be telling the truth about what they said on the witness stand, then the government's theory was totally incoherent with the witnesses' account irreconcilable, whatever. These witnesses provided the essence of the case against Mr. McDavid. The government knew their combined testimony was necessarily incoherent. This is, by definition, a reckless disregard for the truth, which constitutes a frivolous and vexatious position by the government. This entitles Mr. McDavid with reasonable attorney fee. A. Mr. McDavid is the prevailing party. Though the Hype Amendment does not define the term prevailing party, it instructs courts to on the term application in the criminal context. The principle is clear enough as applied to some disposition. An acquittal following a trial would clearly make a defendant a prevailing party. And they gave a case study. Mr. McDavid was acquitted following trial. He is clearly a prevailing party. B. The prosecution of Mr. McDavid was frivolous. The prosecution of Mr. McDavid was frivolous because the position of the government regarding its theory of the case had no coherent basis in law or fact. With regards to count 5 of the indictment, the government produced no evidence which was reasonable juror could conclude beyond reasonable doubt that any overt act furthering the conspiracy was committed within the statute of limitation period. Moreover, Jane and Susan, the government's own witnesses, expressly refuted that there was any payment or gift given to them to conceal or cover up any tangible document. with Jane unequivocally denying that she received any payment in exchange for silence. All that was left was trying to charge to a statute limitation worth settlement payment Kelly made to Mr. McDavid in 2014-2015 after contentiously litigation lawsuit. However, the government did not introduce shred of evidence that the settlement involved anything other than a lawsuit for legitimately earned money owed Mr. McDavid. Not a single witness gave any such testimony. There were there was certainly nothing that could be indicative of guilt or beyond a reasonable doubt when there was no actual evidence saying that any payment made in 2014 was connected to the 2008 case in any way. In regards to counts 6 through 8, the government's story was simply not supported by facts. Freeman said he obtained a tape that Van Allen took from Kelly with some residents in Georgia after Van Allen told him where to find it. Van Allen said this never happened, and she claimed she took one tape and it never went to Georgia. It went only to Keith Morrell. Freeman said the tape he recovered in Georgia had threesome scene in it. Van Allen said the only tape she took had threesome on it, two with Kelly and one with Jane alone, and one threesome scene. Morrell said that the only tape he received had no scenes with just Kelly and Jane. Had no scene with Kelly and Jane. It was one threesome scene of Kelly and two women. Yet the government's position was the tape Freeman obtained came from Van Allen. Their position was that the tape Van Allen took had all three seen, and it was ultimately given to McDavid by Morrell. The testimony of their own witnesses made it plain that this position could not be true, and yet they took that position in front of the jury. There is no way they did not know it was incoherent based on the witnesses' testimony. This is no way they did not know that this position was irreconcilably inconsistent with the testimony of their own witnesses would give. Yet they presented it to the jury anyway. That is at best reckless disregard for the truth, and that makes this prosecution frivolous. C. The prosecution of Mr. McDavid was vexuous. Vexuous. The investigation and prosecution of Mr. McDavid was vexuous because it was without reasonable and probable cause or excuse. There was no excuse for claiming that payment after 2014 was for the purchase of silence when the people who received the payment said there was no such purpose. There is no excuse for claiming a legal settlement between Mr. McDavid and Kelly was for illicit purposes when there was no evidence of that whatsoever. There was no excuse for propositing a theory to the jury that the videotape given rise to count 6 through 8 that was incoherent and could not possibly.
Sorry, I'm still not sure about that.
Oh my God. Shut up. And could not be possibly true based on the testimony of their witnesses that makes this prosecution vexuous. D. The prosecution of Mr. McDavid was in bad faith. Bad faith is satisfied with when the prosecution knowingly and recklessly pursue a frivolous claim. United States versus Shigan. Or act in a reckless disregard for the truth. Thus, the foregoing discussion is equally relevant to finding of bad faith. In this case, the government apparently made no effort to determine which, if any, of the witnesses irreconcilably stories were true. Rather, they operated under the strategy of presenting a position to the jury that their witnesses collective testimony render incoherent. That is reckless disregard for the truth. After misleading the grand jury as to Lisa Van Allen's testimony, to mischaracterizing the evidence, its opening argument, to relying on witnesses who had told so many various stories that the government could not ascertain if a witness had perjured themselves or not. The prosecution in this case continuously illustrated a reckless disregard for the truth. That means this prosecution was in bad faith. Mr. McDavid's reasonable fees, Mr. McDavid's attorney fees are reasonable. The Height Amendment itself provide for the award a reasonable attorney fee, 18 USC 3006A. Note, the calculation reasonable attorney fee, this court has applied the lodestar method, multiplying the number of hours reasonable expended on their litigation by a reasonable hourly, whatever, blah, blah, blah. In the defendant in defending his freedom, Mr. McDavid incurred $850,000 in legal fees, $600,000 of which was outstanding, which must be liquid. Oh wow! Must now liquidate his real property and other asset in an attempt to pay. This amount is reasonable given an immense work that went into defending his high-profile 3 years prosecution. The flat fee, when broken down hourly, it clearly is reasonable. The 2 months before trial, underlines counsel worked on this case for an average of 80 hours per week. That increased on an average of 100 hours per week during the trial. Adding that this is over 500 hours discovery reviewed. Wow. That the undersigned counsel completed, in this case, $700 in reasonable per hour as a reasonable mark for rate and service rendered given the undersigned expertise, level of success, and experience. On top of that, law firm of Van Dam and Glossman also work hand in hand with the law firm of Bo B. Brentley throughout the preparation for an execution of the trial in this case. Using the conservative estimate of 1,280 hours worked on this case, $850,000 reduced to the hourly of $696.72. The rate in which the case is immensely reasonable. Conclusion: Mr. McDavid's life was unalterably changed for the frivolous and vexatious and bad faith prosecution over which he prevailed. The Hype Amendment and Equal Access to Justice Act entitled him to recover reasonable attorney fee. Wherefore, Mr. McDavid respectfully requested an honorable court grant his motion and will award him reasonable attorney fee in the amount of $850,000. All right, that was it, y'all. My throat is itching. That was it. What do y'all think? Lady?
I think he should get his money.
Y'all, let me tell you something. This is going to help Robert.
Yes, it is. I can tell.
Absolutely. Because and then y'all, I'm gonna send y'all. This is what I want y'all to help me with. What I'm going to send y'all now. My throat is itching, y'all. Oh my gosh, my allergies acting up.
I don't want to say nothing, but as far as what you was reading to me, man, they had no reason to even bring Mr. Kelly to trial. Period.
Yeah, but did you hear this? The whole thing was crazy. Oh my God,
Yeah.
this is the proof that we need. This is the reason why they have been coming after us so bad. Because they don't
Wow.
want the truth read. They don't want us to talk about it over the internet. They don't want people to be informed. They want people to stay in the lies, y'all. This is why. This is the reason why I am going through so much hell in my life right now.
Mm-hmm.
This is
Can
the
you hear
reason
me
why
clearly,
they don't want.
Sylvia?
Huh?
Yeah, you good.
Oh, because
We
I
can hear
sound
you.
like I'm muffled. Okay.
Now we hear you.
Okay, good. I'm sorry.
This is the reason why. This is why the hate is so hard on this platform. This is why. This is exactly why, y'all. They're trying to hush us. They're trying to keep us from putting this out. And I'm telling you guys, please, please share this video. If you don't do anything else, share this video. And then I'm going to put on this other part so you guys could share this video, please. It's necessary. It's important. And I'm trying to make these videos as short as possible. It's hard to make it short when you have so much nuggets. You get what I'm saying?
Right, right. I get what you're saying.
Share
So what?
this
You
video.
got a video that you finna play or something? Or you got something else to
No.
read?
Share. There's another part to read. But what I'm
Okay.
going to do, I don't know if we would. What do y'all think? Do you think we should end this and put another video out? What do you think?
Yeah, because like you said, people don't like those long videos. I don't know what you
Okay,
think,
I'm
Sylvia.
going to end this and then we're going to go read the grand jury testimony. Okay? I'm ending this. We're going to
Okay.
start with grand jury. And y'all, I'm taking a day off. So y'all actually need to send some cash out to your sister here because I'm taking a day off to do this, y'all. Come on, hit my cash app. Hit my cash app. Give me what I would be making outside right now. All right, I'm going to end this live. Come on, y'all. I normally make what? How much I make a day? $200? I need
Yeah, that's what you
$200 in my
said.
cash app today. Y'all cash app me the $200. And so it could be worth my while sitting here today. All right, let me end this. Let me end this. Mides, put my cash app up. Thank you. Put my cash app. Let it rain, y'all. Let it rain. Do y'all want to hear the grand jury testimony? If y'all want to hear the grand jury testimony next to the next live, hit my cash app. And I'm serious. There's 100 of y'all being nosy up in here. Y'all need to do something for your girl. Thank you, pretty eye. Okay, you gonna help me out, Tamira? Can you read? Oh, you busy with the kids?
No, I can read, Sylvia.
Okay. All right, I'll send it to y'all. Guys, I'm gonna redo it again. So hit the cash app. They go my cash app,
You want me
my
to leave this? You want
Venmo.
me to leave this?
I'm gonna end it.
Leave?
Yeah, you leave. Yeah.
Okay.
All right, y'all. We're gonna read the grand jury testimony. All right. Good is laughing. Come on, y'all. Hit the cash app. I don't hear no cash app ringing here. Hold on. Let me see if the rec. Let me see one person, at least one person hit the cash app. Where we go? Where we got the cash app? Cash app, Venmo, PayPal. That ain't no cash app. That's a text message. So don't even try it, y'all. Don't even try it. That ain't the cash app. All right. Y'all let me know if y'all. There ain't nothing coming through here. Nobody hit that cash app. Okay, that means I ain't coming back on. All right, y'all don't want me back on because y'all ain't hitting the cash app. No cash app, no Sylvia coming back on. And I'm not playing. Okay. I got one cash app. Thank you, pretty brown eyes. Thank you, pretty brown eyes. All right, you hit the cash app. All right. So y'all better hit the cash app. Y'all want me to come back on. Pretty brown eyes have help out a little bit. Hit the cash app. Nope, they didn't hit the cash app. Only pretty brown eyes hit the cash app. All right, they don't want to hear it then. Okay, bye. I'm gone. If I don't come back, it means nobody hit the Cash App. If I come back, that means the Cash App was hit. I made my number. All right. Bye, y'all.